Ganatra, Senior Assistant Prosecuting Attorney for the People.
Assistant Public Defender with and on behalf of Miss Dejour Exton, who appears to my right. Can you state your name for the record, please?
Dejour Exton.
Thank you. Your Honor, today's the date and time set for a probable cause conference. My wishes are to proceed and move forward with this matter. I spoke with Mr. Ganatra earlier this week. He wanted to go over the progress report from Ms. Exton.
Go over what?
Do you have a copy of that? It's dated March 12th.
I have a few extra.
I don't. Let me see. No, I don't have a. We've got to figure that out. Because
The council has an extra copy.
I do, Your Honor.
Sharing the report.
is she on a benzo?
Yes, Your Honor. She's prescribed that medically.
On 3-5, why do I have a missed test?
Your Honor,
Because, and I'm just going to place that in context, because on February 29th, because we had all of those missed tests before, I had indicated there was to be no further missed test.
exactly, Your Honor.
So why did she miss a test, Mr. Allen?
Your Honor, if I may, if you recall, Ms. Exton appeared at that probable cause conference via Zoom. I put on the record, I let the court know that she had a funeral arrangement set up on the 4th of March. Ms. Exton, outside of her 2-year-old daughter who's at home right now, there might not be anyone she loved more than her grandfather. Her grandfather was buried less than 24 hours from the time she was supposed to test on the 5th of March. So she called community corrections, she spoke to the agent, and they arranged her to test on the following day, which she did. And I believe this is about the 7th probable cause conference Ms. Exton has appeared for. At this point, she is mentally and physically wore down. And how I know this is because I've had the pleasure of getting to know Ms. Exton, getting to know her family. I've spoken to her father. I've spoken to her grandmother. Every time I call her, she responds. If she doesn't answer, she calls me right back. 90% of the time I speak with her 2-year-old's in the background, laughing and screaming. And she's just, Your Honor, what I'm trying to say is I would be here all day if I had to tell you how much Ms. Exton has gone through. She is financially struggling as a single mother with a 2-year-old at home.
I understand all that, counsel.
Your Honor,
My issue is the missed test.
and Your Honor, this goes to the missed test. She just buried her grandfather. She has been on bond testing for 5 months consecutively. Every result that is on that bond form, she's medically prescribed to. And when she misses tests, she's communicative. I truly believe that progress reports are subjective. And
Subjective in what way?
if you look at the circumstances here, the effort, the totality of testing for all these months, is she perfect, Your Honor? No, absolutely not.
And
And
why am I getting this long argument? I just asked about the missed test. I think you've given me that answer twice. That's the only thing I asked for.
Your Honor, I'm just trying to explain to you why she missed that test. There's a lot going
Well,
on.
I know you explained to me. Her grandfather's a funeral and then she made a makeup test.
Yes,
That's all you had to point me to.
I just want to protect my client. That's all. I'm trying to move this case forward. Sorry if I overstepped.
Mr. Ganatra, was that what you wanted addressed? The missed test?
Yes, Your Honor. And I will acknowledge there was an offer made, which is open, and it will be honored at some point. but counsel asked about writing up the offer for today, knowing that this progress report specifically alleged actions by the defendant which were in violation of the court's stated order 29, which this report even acknowledges in there. It's the last sentence on the report. This court ordered only this test, and that's what happened. I told them that I wasn't going to bring that plea offer today because I wanted the court to address this community corrections issue before I did a plea. And it's worth noting the next day there's an abnormal creatinine.
Yes.
Which is not very significant, but I'm just going to defer to the court on that because it's the court's order. That's what I wanted to bring to your attention today.
That could be anything. That could be.
Christian, if I put this out 3 to 4 weeks, can you make every test
Yes,
and not miss a test?
yes.
I'm going to adjourn the probable cause. So hopefully you'll be able to take advantage of any offer they made to April 11th, 2024, 9 a.m.
Thank you so much, Judge.
And I'm just gonna indicate no further missed tests for any reason.
Okay. Thank you.
Thank you.
Court calls the case of the people versus Diana Johnson.
Public defender and Johnson. Johnson, will you state your name for the record?
Diana Johnson.
Thank you.
Your Honor, to the the first probable cause conference of this case, I'm asking for an adjournment where we requested some video discovery that I still need to review.
April 4th, 2024, 9 a.m.
Thank you, Your Honor.
Bond will
Thank you.
continue. Thank you. Court calls the case people versus Bruce Jones. Your name? My name is Bruce Jones. Senior counsel. This is a PD case. Stepped outside. Where'd she go? She knew she was cutting her case called. Come on, Coons, get up here. Client's been waiting an hour.
Sorry, Your Honor. This is Bridget
You gotta
Coons.
apologize to him. He's the one that was saying bad things about you.
Sorry.
I was covering you. Yeah.
Your Honor, Bridget Coons on behalf of Mr. Jones. At this time, we would be just requesting a 1-week adjournment if possible. I got the video. I haven't had a chance to review it yet.
I'll give you, and then he's got to see it. Right?
Yep.
So why don't I do this? Probable cause conference, April 4th, 2024. 9 a.m. bond will continue. All right.
Thank you.
Thank you, sir. Court calls the case of people versus Maurice Jones.
Bridget Coons on behalf of Mr. Jones.
Maurice Jones. What are we doing?
Your Honor, we'd like to set this one for a preliminary examination.
You see the bond violation report?
I do. So I did have the opportunity to talk to Mr. Jones about this. He does have his medical marijuana card.
Okay, does he have a medical cocaine card?
He does not. Whenever I spoke to him about it, he did inform me that he is retesting for those. Based on
What?
he is retesting for the March 11th or sending it into the labs. Whenever we discussed it, he explained to me that he did have a another test done. His test came back negative. Okay, a 12 panel. His test came back negative, but the Lenawee County came back positive. So he is disputing that
His test came back,
negative.
which test?
From my understanding, it's the March 11th, correct? And then did you also do that for the January 31st?
Yes.
Yes.
Well, the previous ones that I violated on, I wasn't, I was.
Okay, before you go on, okay, because, I mean, I'll let you go and explain anything you want to explain. I don't have a problem with that. However, looking through your report, you continue to test positive for marijuana, but from September 2023,
Yes,
there was cocaine in your system.
yes,
November 11th, 2023, cocaine in your system.
yes,
December 18th, cocaine in your system. January 31st, cocaine in your system. March 11th, cocaine in your system.
I'm only think about it. It's a cop where I'm testing that.
Pardon?
Where I'm testing that in Lenawee County, it's a cop with other matters I'm dealing with, and I'm going through a thing right now where they're setting me up. I started bringing my own panels to the place that I drop at. They use a dip thing, and I use a urine test, and my test came back up negative, and they test came back up positive. And I'm telling them I never even did cocaine. And I ain't even about to sit right there and try to justify it in court. That's why I accepted one of the violations. But Fresh Harbor told me if I honestly didn't do it, fight it. And I never even did know. And it have to be in you. I looked it up, I read about it. So now I started going in there and taking my own test. And I have witnesses with the people that I took the test with at the place just on the 11th. That mine showed negative.
I just gave you all of the dates that you tested positive for cocaine.
No, but I wasn't smart enough to, funds.
I just gave you the dates that you tested positive for cocaine.
I only think
You're telling me that all of
all of
those
them
are
negative.
all of those are wrong.
Yes, all of them. Every last one of them. And I won't sit right here and lie to the court. But I did accept.
You want me to call over and get the levels of cocaine that were in your system? Because they have them.
But I've never used in my entire life, ever. And that's why I wasn't smart enough in the beginning with buying my own tests to go there. I was using them at home. But then on the 11th, I told myself, like, why am I doing them at home? I need to be doing it in front of the people so they can see that, blah, blah, blah. And then the person that tested me there, I dropped with mine, and he tested me with the dipstick, and the dipstick showed that I was positive, and my test showed I was negative. And he took a picture of it. I got photos of it. His name is Mike. And I never used, and I won't sit right here and lie to the courts when I drop twice a week for the last. I don't miss a test, so why would I actively use cocaine once a month? I'm from Detroit. Why would I actually use cocaine once a month if I'm an active user? And then I'm going to every court day. I'm going to every schedule. I don't miss one. I'm saying I don't miss a drug test.
You don't know Shakespeare, do you?
No. I just don't miss a drug test. So I wouldn't come to your court and tell you to your face that I don't do it, but I haven't missed a drug test, but I'm doing cocaine. Like they setting me up, and I'm trying to handle the situation, and I am handling it with the lawyer. I talked to her, and she said she can help me with the matters of up there, but I'm testing there, and they're setting me up. And that's all I can say. Other than that, I've never used in my life, and that's on my son, my mom. But anyway, I've never used in my life, ever. Not, nothing, ever, nothing.
You done?
And I ordered a swab, like, cause once you drop. Okay.
Your Honor, I advised him that if he wants to dispute them in the future, he has to do that with the Lenawee County, basically send it in for testing.
That Lenawee County did what?
That he would have to send it in for testing if he wants to dispute that in the future.
Is he taking them here or in Lenawee?
And Lenawee. And then it's basically getting sent to the community corrections here.
Mm-hmm. I don't know. I probably looked at what seems like probably a million of these. The odds of this happening are like nil. So when are they supposed to have the results of the test from the 11th?
We received any information for that?
No, you just told me I had a violation for it. My
Has he ordered a retesting of that sample?
Have you, besides the original test?
the one on the 11th.
Yeah.
Yeah, well, with the dude Mike, the new dude. Yes, he took
What?
Yes, with the new dude Mike, he took a picture of my tests and was supposed to send them in, and it cost $60. Yes,
You took a picture of your test.
of mine in the test, sent it to the probation officer or the bonds officer, and yeah, they were supposed to send it out, but I never even knew I had this violation because when I left out of the place, we was all good. He would have told me that I dropped. He would have told me that I dropped positive, and he never told me that. And I stayed there until all my tests is clear.
So why is it being sent out to be retested?
Yes, it should be. And if it's not,
Well, hold on. What do you mean it should be?
Did you pay the?
Did you do it?
he never told
Did you do it?
No, because he never told me that I was.
Hold it. I just thought you told me that he did.
I was under the understanding he did. I think that he might.
Yeah,
be-
well, that's what he also said in his little soliloquy he was giving.
No, I know. He told me I was good. He said he would handle it. If Darren said something that he was going to handle it. So I ain't pressed the issue because I knew I was clean and he seen it on the thing. So he told me I could.
When?
You said when?
He's like a young man.
March 11th, you test positive for cocaine again.
Want to still be on my system now if I did it that early or some type of hair follicle blood.
March 11th, you tested positive for cocaine again for the 5th time.
And all of them, I never did cocaine in my life. And it's hard based off the cases I'm dealing with, but I can't make you believe, but I won't come to court if I violated 5 times. Knowing this.
You know what? You keep talking to me, and that's not going to stop me from doing what I'm going to do, but I'm going to let you go on and get everything out. You then told me that you were sending that one in. And now I find out you haven't even sent that test in. And then you're telling me that I didn't know that it was positive and that you didn't know about this. What you're telling me doesn't even make any sense. You haven't sent that sample back to be tested, have you?
No.
Why not?
Because Mike said he would handle it once he talked to Darren. Because my test came up negative. His test came up.
Well, the PD is going to have to call up and try to figure out what the heck's going on up there in Lenawee then, because I'm just telling you, you don't see this.
Can I ask you a question since you're the judge?
Go ahead.
I just want to know how many active users have you seen drop 8 times a month and drop 30 once? I dropped 31 since.
How many active users have I seen do that?
Yeah.
Young man, I've been on the bench almost 25 years. How many do you think?
Like once, I assume they might drop it twice, 3 times.
Let's do it this way. Because I think he's going to have to learn to tell me the truth, because that's not the truth. This doesn't happen. And if you think you're going to get up here and just kind of try to fast talk me into doing something, no,
I'm not,
it doesn't work that way. And why would you know anything about active users and how many times they would drop dirty in a month?
only because I done been in the system.
Cause conference will be adjourned to next week. That's the March 21st, 2024, 9 a.m. Council, you can maybe have that conversation about coming before me and telling me the truth, but at this time, defendant's bond is revoked, remanded. Yes, sir.
Hopefully, so you need the record.
That we just did.
You have to state your name.
Jason Travis Pope.
Thank you. My understanding is he's waiving preliminary examination. Is
Correct.
that correct, sir?
So what you wish to do?
Yeah, I got a few questions.
Well, those are probably directed to me, not the judge.
No, that ain't directed to you. You're not my judge. All right, I have a few issues and cases that matter. I was supposed to get sentenced yesterday. They adjourned it. Now, this is a new case that happened during the same string that.
Hold on, you're
Yeah.
supposed to get sentenced where?
Your Honor, he had sentencing before Judge Conlon yesterday. He is correct in saying this isn't necessarily a new offense. It just was charged later. So the sentencing before Conlon was adjourned. The understanding in our discussion is that he was going to waive his right to an exam on this case and try to get it up there to reach a resolution to be
Is that the right
sentenced
way to do it?
altogether.
Is that the right way to do
The
it?
judge can't give you legal
I can't,
advice.
right, I can't give you legal advice, but Hank?
Yeah.
Yeah, that's exactly why Ms. Apple's here.
Okay,
Yes.
And you should listen to her because she knows more than me.
okay.
Okay?
Or
Yes,
stretch,
sir.
but thank you.
All right.
I was going to waive that right.
Okay, so you'll waive that right. You understand that preliminary examination would be a hearing and you're not going to have that hearing. And you're going to go up to circuit court before Judge Conlon with your other case. You
Yes, sir.
understand that?
Yes, sir.
All right.
Yes, sir.
People also waive their right.
Oh, no, you're okay.
Preliminary examination having been waived, defendant is bound over to circuit court on the 2 counts. Ms. Apple.
Your Honor, we would acknowledge receipt of the information, waive its formal reading, stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 27th at 1:30 before Judge Conlon.
March 27th, 2024, 1:30 before Judge Conlon.
Before comment at that time. Okay. All right.
All
Thank you,
right,
Judge.
bond
Thank
will
you, sir.
continue.
Have a good one, man.
You do the same.
Thank you, Your Honor.
Thank you. Oh. Blondie was here too long because see, Nimish always asks bad time the information. She just walked up.
That's what I did.
That's exactly what she did.
Yeah, I felt like risking contempt and snapping.
A couple more recalls over.
Yeah.
Okay, because that's.
Oh, I know. Court does call the case, recall the case. People versus Charles Kane Cross.
Assistant Prosecuting Attorney.
Deputy Store Assistant Public Defender. Your Honor, I was not able to locate Mr. Kane Cross.
But he was here,
He was here.
then he left.
He left.
Defense warrant will issue for defendant's failure to appear. Bond will be set in the amount of 25,000 cash surety. The file will be noted that the defendant was here and then left. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls the case People versus David Rasmussen.
Image Finatra, Senior Assistant Prosecuting Attorney.
Two cases.
Matthew, Miller, Assistant Public Defender, with and on behalf of Mr. David Rasmussen, who appears to my right. Can you state your name for the record?
David Rasmussen.
What are we doing?
Your Honor, today's the date and time set for a probable cause conference. I'm going to ask for just a short adjournment. I want to go over the police report with Mr. Rasmussen again. He was just arraigned on a new charge over this weekend, so just
A new felony?
yes.
So we got another case coming up?
Should be the second file on the.
Oh, I see. Okay.
Your staff was very responsive to the request of the public defender to add it to today's docket, so they did that.
Oh, don't do that again. Never mind. You want a couple weeks out then?
Yes, Your Honor. That'd be nice.
Probable cause conference, March 28th, 2024, 9 a.m. Bond will continue. Thank you. Recalls case of the People versus Sandale Burns.
Image Finatra, Senior Assistant Prosecuting Attorney for the People.
Case People versus Todd Salisbury.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Salisbury. Salisbury, would you please state your name for the record?
Todd Michael Salisbury.
We're asking that this case be set for a preliminary exam.
Discovery complete.
It is.
Would the people have their witnesses available on the 26th?
Yes, Your Honor.
Preliminary examination will be set in person March 26, 2024. 9 a.m. That's before me.
Your Honor, may I address bond very briefly?
Sure.
I'll make it brief. The court's very aware of Mr. Salisbury's situation. We are just asking the court to consider a 10% option on the bond that is currently set.
I denied the bond reduction the last time out. I don't see anything necessarily that's changed. So I'm going to deny the motion for bond reduction. I'll certainly reconsider it after I hear the preliminary examination or at the time of preliminary examination.
Understood. Thank you.
Thank you. Case People versus David Copeland.
Ready in that matter. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Copeland. We were able to get in contact with Mr. Copeland. He was unable to arrange a ride. He should be by Zoom.
He was unable.
Should be on by Zoom.
Yeah. He was unable to get himself here?
Yeah, he could not arrange a ride, so he did the next best thing, got it by Zoom. That's
all right. Okay, Mr. Copeland, my understanding is that there may be a withdrawal coming in, or no?
So, yeah, that's a correction, Your Honor. There was a Davion Copeland that we had to withdraw from. I think there was some kind of confusion as between the two. So
got it.
Not withdrawing.
You're not withdrawing on this one. Okay.
Continuing our representation.
So you need an adjournment, however?
We do, yes.
All right. Mr. Copeland, I'm going to grant the adjournment. I'm going to adjourn your probable cause conference to April 4th, 2024, 9 a.m.
That one will be in person?
Yes, sir.
Okay, I'll make sure I have a ride arranged for that one. I zoomed this morning as well. I didn't have a ride. I apologize.
No, it's okay. Thank you for the note. All right, take care. Bond will continue.
So that's April 4th, Your Honor?
Yes, sir.
Thank you very much.
Court calls the case of the people versus, is it Miko's Talk?
Judge Simpson's ruling highlights an important principle of the legal process. Courts often rely on documented evidence and consistent records rather than explanations alone. During the hearing, the defendant strongly denied using cocaine and claimed the test results were inaccurate, while also describing concerns about the testing process. The judge, however, focused on the repeated positive test results and the lack of verified evidence supporting those claims at that stage of the case. As a result, the court revoked the defendant's bond while the matter continued through the legal process. This hearing shows how credibility, compliance with court-ordered conditions, and reliable evidence can significantly influence judicial decisions. Since these are allegations discussed in court, the final outcome depends on the full legal process and any evidence presented later. What are your thoughts? Did the judge make the right decision based on the information available, or should the defendant have been given more time to support his claims?